Recently, Shri Amit Shah, Union Home Minister, introduced three important bills in the Parliament. These are the Bharatiya Nyaya Sanhita 2023, the Bharatiya Nagarik Suraksha Sanhita 2023 and the Bharatiya Sakshya Bill 2023. These bills seeks to repeal and replace the Indian Penal Code 1860, the Code of Criminal Procedure 1973 and the Indian Evidence Act 1872 respectively. Sedition is no longer considered as an offence, though new bill penalizes the following: exciting or attempting to excite secession, armed rebellion or subversive activities, encouraging the feelings of separative activities, or endangering the sovereignty or the unity or integrity of India. Terrorism has been added as an offence. Terrorism includes an act that intends to threaten the unity, integrity, security or economic security of the country, or strike terror in the people or any section of the people in India. Punishment for attempting or committing terrorism includes death or life imprisonment and a fine if it results in a death of the person. Organized crime has been added as an offence. It includes the crimes such as kidnapping, extortion, cybercrime committed on the behalf of a crime syndicate. Petty organized crime is also an offence now. Mob lynching has been made an offence. The new bill adds murder or grievous hurt by 5 or more people on a specified ground as an offence. These grounds include race, caste, sex, language or personal belief. The punishment for such murder is life imprisonment or death. For several minor offences, community service has been made an option of punishment instead of imprisonment. For hit and run, the punishment is up to 10 years imprisonment, but if after the incident the offender takes the victim to the hospital or police, lesser punishment will be given. Introduction of zero FIR, as per which the police officer has to register the FIR irrespective of where the offence took place. The new bill mandates forensic investigation for offences punishable with at least 7 years of imprisonment. In such cases, forensic experts will visit the crime scene to collect the forensic evidence and record the process on mobile phone or any other electronic device. The old CRPC empowers a magistrate to order any person to provide specimens, signatures or handwriting. The new bill expands this to include the finger impression and voice samples. The new bill allows these samples to be collected from a person who has not been arrested yet. The new bill prescribes timeline for various procedures. For instance, it requires medical practitioner who examines the rape victims to submit their report to the investigating officer within 7 days. Other specified timelines include giving judgment within 30 days of the completion of the argument, though expendable up to 45 days, informing the victim of the progress of the investigation within 90 days, and framing of charges by a session court within 60 days from the first hearing on such charges. Now the police custody of the 15 days can be authorized in whole or in parts at any time during the initial 40 or 60 days out of 60 or 90 days period respectively. The new bill provides for the use of the handcuffs during arrest. If a proclaimed offender has absconded to evade the trial or there is no immediate prospect of arresting him, the trial can be conducted and the judgment can be pronounced in his absence. As per the old CRPC, if an accused has spent half of the maximum period of imprisonment in detention, he must be released on the personal bond. This does not apply to the offences punishable by death. However, as per the new bill, this provision will also not apply to offences punishable by life imprisonment or the person against whom the proceedings are pending in more than one offence. The old Indian Evidence Act provides for two kinds of evidence, documentary and oral. The new bill now classifies the electronic records as documents. Under the Indian Evidence Act, the electronic records are categorized as secondary evidence. The new bill makes the electronic records as primary evidence. Further, it expands such records to include the information stored in the semiconductor memory or any communication device such as laptop, smartphone, etc. The new bill expands secondary evidence to include oral and written submission and the testimony of the person who has examined the documents and is skilled in the examination of such documents. If you like this video, kindly like it and share it among your friends and subscribe to my YouTube channel for such informative videos. We'll see you in the next one.